take an agenda.
I'll take an agenda too, please.
Same here, Lori. How much did you pay?
I made enough for the Alright, I'm already mesmerized by this.
I didn't get one either.
I handed you.
No, that's.
Yeah. So in an effort to comply with the discussion we had, we've been at this since about 8:30 this morning. We just finished. So the copies are still being printed of the documents and the statements and so forth, so. Yep.
Is that the current MOU? Would I be able to?
excuse me, for Lori to get down here, maybe we can introduce ourselves. Tom Marcus with the city. Jim?
Shane Salberg with the IAFF.
Dean Garrison, IAFF.
Aaron Payne, IAFF.
Jason Williams, IAFF.
Shaun, Interim Fire Chief, Lawrence Douglas County Fire Medical.
Tammy Boozer, City Attorney. I'm Casey Toomey, Assistant City Manager.
Doug Green, Division Chief, Fire Medical.
Jill Joliker, Douglas County.
If the audience would like to introduce themselves, they can. If they choose not to, that's fine too.
I'm going around with the Lawrence Fire Department.
Chad Gunderson, Fire Department.
Dave Sherman, Fire Medical.
Big Simon, Fire Medical.
Welcome.
I'm Michelle Valverde, City Hall, General.
And Lori.
Roy Carnahan, Human Resources.
Okay, so everybody has received a copy of the agenda. Any questions as to the agenda? From IAFF or from the city side? Next is the opening statement. You have it in front of you, Dean.
Yes, sir.
I'm gonna give you the first opportunity. We'll rotate, but why don't you go ahead and read the opening statement?
Opening statement. The purpose of these meetings is to discuss issues concerning wages and/or fringe benefits and/or working conditions between the city of Lawrence and the elected representatives of the IAFF Local 1596. Pursuant to Resolution 6817, these discussions are to be open to the public unless it is mutually agreed to have them closed to the public. However, there will be no public comment during these discussions. Observers are expected to remain silent and are asked to silence their cell phones. Proper decorum for a business meeting shall be observed at all times. Anyone who disrupts the meeting will be asked to leave. Ground rules have been previously agreed to by both parties. The city manager and the president of the IAFF Local 1596 will co-chair the meetings. The city and the IAFF shall designate a backup co-chair for the meetings. These meetings will be recorded and posted to the city's website.
Any questions about the ground rules? Okay. So next on our agenda is to exchange proposals. And I think we have received the proposals from IAFF, and you have received our proposals. I think it might be appropriate for each side to walk through, if you would care to do that for your side.
Yes, sir.
Go ahead.
So, as you said, you guys have received our interest and proposals. They are listed in order in the order they appear in the contract currently. We do want to say before we start that we believe the contract is, it should always be something that stands on its own merit as it's mutually developed, and these negotiations should just essentially be updates. Shouldn't be anything that's contentious or shouldn't be any real sticker shock. We've taken careful consideration in our list. It may seem short, but we did that deliberately to ensure that it's fair and balanced and contains items that can be negotiated within the time frame. So we'll start.
And can we ask questions as this evolves, or do you want to just finish and then ask?
Well, if I read, maybe touch on something a little bit, but it's my understanding that these will receive their own
That's fine.
their own time during negotiations to be thoroughly discussed.
That's fine.
Okay. So, number one is compensation. That's Article 8, Section 8.2.1 and 8.2.2 wage adjustment. The interest of the union is to establish an annual general wage adjustment. The proposal of the union is to base this wage adjustment calculation on CPI. Number two falls under terms and conditions of employment, Article 9, Section 9.4.2, sick leave. The interest of the union is to have a sick leave accumulation cap in line with comparable cities. The proposal of the union is to remove the sick leave accumulation cap. Number three, terms and conditions of employment, Article 9, Section 9.10.2, uniforms and safety equipment. The interest of the union is to increase the annual shoe allowance and to update the section to include supplemental clothing items. The proposal of the union is to change the annual shoe allowance to an annual shoe/clothing allowance and increase the amount from $125 to $500. Next is terms and conditions of employment, Article 9, Section 9.18.1, minimum staffing. The interest of the union is to maintain staffing levels necessary for safety and operation effectiveness. The proposal of the union is to include language that minimum staffing meets or exceeds the recommendations of NFPA 1710. Next, terms and conditions of employment, Article 9, Section 9.19, funeral benefit. The interest of the union is to increase the line of duty death funeral benefit. The proposal of the union is to increase the funeral benefit from $3,000 to $12,000. Next is terms and conditions of employment, Article 9, Section 9.24, voluntary demotion. The interest of the union is to recognize and adopt the mutually agreed upon policy procedure language developed by Labor and Management for voluntary demotion. The proposal of the union is to update this section with that policy/procedure.
Okay, so the understanding is these are your primary concerns, and that we'll get into details of these as we negotiate forward.
Yes, sir.
Okay. In terms of the city's initial interests and proposals for IAFF, the City of Lawrence has 3 priorities from which the city team has focused its interest and proposals. They are internal equity with other city employees, market competitiveness with area employers, firefighter, medics, and management rights per the City of Lawrence Resolution 6817. Additionally, the city team wishes to streamline items that are identical in the Memorandum of Understanding alongside other documents such as department policies and procedures and the city employee handbook in order to allow for clarity. So what you'll see, and we did this in the case of the LPOA too, where your language in the contract is identical in particular to the employee handbook, we quote the section and then we just say it's in the employee handbook. I admit that that's in part for the administration of not just your document, but the LPOA document and the relationship with the Employee Activity Committee. So that where we have commonality, it's referred back to the employee handbook. In the case of the contract, we suggest that we add an appendix and we take all of the provisions that we're referring to the employee handbook and put them as an appendix to your contract. There's a couple reasons for that. Primarily, that means that you will know exactly which particular language we're using, so that if language were to change subsequently, that would have to be negotiated with you. So it's identical information, but instead of trying to discern whether it's different, every time we look at a provision in your agreement or the LPOA agreement or for the employees at large, we know that it's all the same. So I want to make that clarification about that particular issue. And you'll see that we have a common reference to that as we go through the larger document. Internal equity. There is a city interest to treat employees equitably across the entire city organization. Employee wages and/or working conditions are outlined in the employee handbook and various city policies. I went through that part of it. In addition, departments have policies that govern the conduct of their employees and procedures that direct how city operations are to be carried out. In addition, the city has a Memorandum of Understanding with 2 employee organizations, IAFF and LPOA. These MOUs outline the wage and/or working conditions for employees covered by the MOUs. The city operates 3 pay plans for its employees. The primary pay plan, which covers most employees, the police pay plan, which covers officers and detectives, the fire pay plan, which covers firefighters, engineers, fire engineers, and fire lieutenants. Next, major priority is market competitive. The city recognizes that in order to recruit and maintain highly skilled employees, the city must offer compensation and benefit programs that are competitive with those agencies for which we compete for recruitment of quality staff. The city has an interest in providing compensations and benefits that are competitive. Management rights. Resolution 6817 outlines the management rights that the City Commission deems important. Per the resolution, management rights are not subject to discussion. I think this is an older copy here. Discussion, period. Over the years, some of these rights have been incorporated into the agreement. In order for the City of Lawrence to operate in an effective, efficient manner, it is important that those who are charged with the authority and responsibility for carrying out the business of the city have the ability to do so. Therefore, the city has an interest in reestablishing those management rights through negotiation of the various MOUs. Finally, document streamline. I touched on this a little bit in the earlier comments. There are several areas in the current memorandum of understanding that are duplicative to the city employee handbook and the department's policy and procedures. And in some cases, the department's policies don't align with the agreement. And so we're saying that we have to get alignment with those back and forth to make sure that, because quite frankly, the contract supersedes, okay, at this point, if in fact a benefit or a working condition has been established through the agreement, then that's what supersedes. Streamlining of the MOU is important in maintaining efficiency in the organization and is of city interest, as I've discussed. So, when Dean and I talked a little bit on another topic, the conversation of this MOU came up. And Dean indicated that you kind of take a triage approach to your agreement. And I indicated to him that coincidentally, we were kind of on a triage approach to ours as well. What we've done is we've taken all of the provisions of the agreement and we've broken those down section by section throughout the entire agreement. Then we've listed the city's proposals and IAFF's proposal. And then we put a column in there which suggests that as we go through, if we can reach tentative agreement, we would mark those as TA. When we've left a blank, that means we're not proposing any change. And if it's a complete blank, that means that you haven't proposed any particular change. Now, to be practical, I would say reading your proposals, once we get into the specifics, I suggest that it will involve more than just one particular section of the agreement for purposes of how we figure out what, because one part sometimes affects another part of the agreement, and so we'll have to figure that out and work our way through that. I tell you that because I want you to understand, because you presented a very limited list, that doesn't mean that I don't suspect during this process that we're going to have further discussions and other items will come up. Some that will come out of the items that the city presents from the city's side, some that will come from you. That will lead to further discussions. My intent is to reach agreement with the IAFF on this next agreement, which expires at the end of this year. And so while you may, or I may, react to something as we see it first in writing, I think what we need to do is keep the communication flowing, keep our emotions in check. I know both sides have passions in that regard, and we intend to be respectful throughout this entire process in terms of how we get this done and how we explain things. But we are going to reach, I'm sure, occasions where we can't TA something at the present. If you read the resolution, I actually think the resolution was pretty well drafted. And I think what it does as time goes on, it creates some leverages on both sides to reach agreement by the end. Because at the end of it all, you know, you kind of do your last best offer, and it goes to the city commission, and the city commission decides. I'm not anxious for that to happen. I'm more anxious to see matters resolved. And I think that we can all stand on principle, but this is a negotiation. And I always view negotiations as a two-way street, okay? It isn't just one side or the other. I have to understand what your perspectives are. I hope you'll understand what our perspectives are. So as we go through, you know, we need to probably keep our passion and our emotions in check to some degree. And you can remind me of that too if you find mine getting too escalated. But do you or any other members of your team want to say anything before we start going through the specific agreement? Or do you want to talk about how we approach this going forward? Do you want to go through section by section and?
We don't have a preference.
Okay. What we did is we did load the material that you have in front of you on the PowerPoint, so we can go through that and start walking through the different sections to talk to you about it and explain some of it. Sometimes you'll see just a question mark because we really do want to talk to you about maybe some of the history of how that particular language evolved, okay? We found that in the LPOA agreement, some things were in contradiction to the resolution. And quite frankly, some of the things in the IAFF agreement are as well. And some that probably will displease you, and we'll need to figure out how to work ourselves through those more sticky situations. And I'll point those out as we go through. But the question marks, and even some of the ones where we have suggested alternatives, I think they're, in part, they go back to one of these three issues that we mentioned: internal equity, competitiveness, or management rights. And management rights isn't just the management rights issue, it's the consistency between the agreement and the resolution. And we'll point out distinct language, quite frankly, as we go through, that says that what we have refined into an agreement sometimes is contrary to the resolution. Fair enough?
Yeah.
All right. I know the audience isn't supposed to speak during this, so maybe you can just nod your heads or shake your heads to the contrary. Can you read this? Okay. You can move.
I cannot. I may have to go up there if I do much typing.
Blow out the tentative column.
Okay. Maybe I'll stand up there for a little while. Is that okay?
What's
So
that?
I can see?
Yeah, that's fine.
That would be great. also gonna change the mouse around as you get started.
So one of the things that I'm gonna mention right up front is if you read the resolution and you go to I have to find it here. If you go to the third whereas in the resolution, I'll read it out loud. It says, whereas the governing body of the city of Lawrence, Kansas does not intend to formally recognize any employee union, group, or organization as the exclusive bargaining agent of its members. So, in the agreement, it talks about recognizing the IAFF as the exclusive bargaining agent. And as I interpret exclusive, that means singular. Now, my understanding is that unquestionably, the IAF represents the employees. I get that. My only point is that it says exclusive, and our resolution says you're not supposed to make those determinations through the resolution. So one of the things we did, and it also talks about union in there, is we've changed the word union to IAFF, but we've removed the exclusive comment about the recognition part of it. So I don't expect you folks necessarily to respond to any of this at this point. I will point these things out as we go along. I'm not sure we'll get through everything today, but that'll give you a chance to come back the next time and rebut or give us your views on these things too. And then in the next one, it just talks about the term. Here's one of those items, for example, that you didn't really stipulate a term in your agreement, and we're saying pretty much the same. We're not stipulating a term at this point either. You know, there's philosophies back and forth, why it would be longer, why it would be shorter, why it would be, you know, an annual agreement. And, you know, the points of difference on either side are unique to the position of each side, so. We'll figure that out as we go along. I'm trying to remember on preamble, I'm gonna have to ask Lori to jump in on occasion. What were the significant changes under preamble?
We aligned this with some language that we had written last year, and so that both the LPOA and the IFF were matching. And it had to do with the references, IFF versus union, the positions, and then it points back to the resolution 6817.
Okay, so that's where this conversation, or the change in the term union to IAFF comes about. If you'd like, we can even make the local reference to the IAFF as well, if that's your preference.
It's a little more streamlined in line with
Right.
6817.
I think we've talked about duration, successors. We had this conversation again this morning, even though the language had been written earlier. And basically what we're saying here is that this memorandum is the controlling document superseding all previous agreements, all existing unwritten practices between the city and IAFF, and constitutes the entire memorandum between the parties pursuant to Article 4 and Article 6, and we'll get into those explanations as we go forward. Memorandum of Understanding. So here's one of those questions I think Dean or members of your board can get into a conversation with me on. It seemed like there was concerns that the agreement would necessarily be dropped or changed somehow unilaterally because of a consolidation, a merger, or an annexation. And I don't know what was meant by annexation in terms of the fire service, but do you recall the history of how that came about?
We don't know.
Okay, all right. Basically, I think my point or our point in all of this is our agreement. Once we've signed on this agreement, that this is what stands, and all other things, quite frankly, until we open up the agreement again, are what's embedded in the agreement. That's the prevailing document, and we say that in the existing agreement and in the language that we have as well, so. All right, next is the Memorandum of Procedures. What we've done here is we've added some of the references back to the Resolution 6817. And I've used Resolution 6817 as really the authorization. We don't follow state law that allows for bargaining, or do we take the position that our employees can't form. But the way we've done it, the authorizing document is the resolution. That's what creates the ability for us to sit down and meet and confer and enter into MOUs. So we think that that's important, that that be referenced in this document.
Thomas also talks a little bit about the letter of understanding.
Oh, yeah. One of the things that happens with these agreements, and I think some of you have been involved long enough where you've probably known that it's happened with our existing agreements. As soon as we sign it, we start having interpretation issues, right? And so what we came up with in terms of the LPOA agreement was a methodology to resolve those differences. And quite frankly, just since we entered into the LPOA agreement, we've had 3 instances where we've entered into letters of understanding. And I think the letters of understanding clarify situations. Now, they can't significantly alter the terms and conditions of the agreement, but a lot of times interpretations create problems, you know, for 1 or 2 individuals. And Lori, I'm trying to remember, give us a specific example of one of those letters of understanding that we entered into.
One of those letters had to do with, the LPOA uses a competency model for progressing through the latter half of their pay plan. And there had been some discussion of what kinds of things would be included and not included in the upcoming agreement. The LPOA had suggested that a couple were removed, which we ended up removing. But then we didn't really have archived in writing what we would do with the people who were currently getting it. And it wasn't a discussion of really reducing their pay, but we hadn't addressed it in the MOU, so we archived it in a letter saying this is what we're going to do with the people who are receiving it.
And so what did we do?
They kept it.
Yeah.
And we made a special code indicating that it was a grandfathered item
Right.
for those, I think, 2 or 3 individuals.
Right. So then the thought is too that anything that would require a significant alteration is an amendment. And amendments usually wait until the term of the agreement is up for renewal again, and then you go back at it. But some of these memos of understanding may lead to a full amendment of the agreement at the next round. And so you're gonna have all of those memos of understanding attached to the agreement as we develop them. We're working on the 4th one right now with the LPOA. We'll attach those to the agreement, and then as the next agreement comes up, we have a history of what happened, and we'll ensconce that in the writing of the agreement to protect, you know, our memo of understanding for both sides. And I think we had pretty open and easy conversations to get that resolved. Anything else that I should mention? All right. Here's the section about exclusivity, I think, or is this union recognition? Yeah, it says exclusive bargaining agent. And what we've said is, I think, I'd be surprised that you're gonna be challenged by any other bargaining unit to represent the employees of the department. So I don't know that removing that is a significant risk to the IAFF, but to bring it into alignment with the resolution with it, I think is important. We did come up with this language. And again, we've reflected it back to the authorizing document of the resolution. Okay, IAFF,
The last sentence might be appropriate as well,
what's that?
the last sentence.
Yeah, and let me just point out in the resolution that the statement that it talks about, because you're gonna hear us talk about management rights, in fact, we've listed it as a priority. Scope of discussion. Section 5 of the resolution, which is on page 3 of the resolution, reads as follows. Upon certification by the Director of Administrative Services, City Clerk, that a representative has received the votes of a majority of those eligible to vote, meaning in your case, the IAFF, he or she shall be declared sole representative of that employee organization and shall enter into the discussions with the city's representatives in the manner set forth by this resolution. However, the following topics are considered management's rights and are not subject to discussion. Management may direct the work of its employees, hire, promote, transfer, assign, and retain employees, reprimand, suspend, and/or discharge employees for proper cause, maintain the efficiency of governmental operations, relieve employees from duty for lack of funds or lack of work, determine the methods, means, materials, assignments, and personnel by which the city operations are to be conducted, take any actions necessary to carry out the mission of the city, initiate, prepare, certify, and administer its budget, and exercise all powers and duties granted to the city by law. So that's the reference we'll make in that regard, and you'll hear that on other issues as well. This next item is IAFF business, and we've recommended that this be changed from 144 hours to 72 hours, but I think there's some other interpretations that we probably need to explain as well. City shall designate 72 hours per calendar year to be utilized by the IAFF at the IAFF's discretion and subject to chief's approval for the purposes of attending educational conferences and other organized IAFF activities. IAFF time shall not be used for consultation with attorneys discussing litigation against the city. I think that's right out of the current language. Requests for designated IAFF time for this purpose shall be made in writing to the chief as soon as practical. All time used as IAFF time shall be noted on the employee's biweekly payroll record. Any other comments, Lori?
No.
Negotiations, subject to staffing and requirements, the chief will work with IAFF representatives to determine if accommodations can be arranged for the purpose of engaging in the negotiation sessions with the city. IAFF officers may request in writing to the chief permission to engage in IAFF negotiation sessions with the city while on duty. The chief may grant such requests at the chief's discretion. Time granted by the chief at negotiation sessions while on duty will not count toward IAFF time. So you notice the distinction between kind of the current status quo in terms of the hours and what you're eligible to use it for, right? Okay. City proposes to eliminate this section as it is addressed in 5.21. This is the, while on duty, the executive board of the union shall be allowed to attend regular monthly union meetings. We think that's already incorporated above. Dues. Okay, and I think the big distinction here is that we've added the words very specifically that it has to be voluntary. Is that one of the distinctions in there? And that's the same with the LPOA.
We align the process.
And,
so that-
and is there a statutory reference or a resolution reference in that regard? That it has to be voluntary?
I don't,
Do you recall, Tony, how we came up with that? Anyway, that's a consistent position that we've taken both with the LPOA, and their agreement includes that. Anything else in there of note?
No, that procedure was kind of to help our office out, to have the same process for both.
A significant change is we're taking the position that eliminating the payroll deduction for political action committee. As I understand political action committees, this is your engagement in, I would guess, both legislative and political activities that you choose to involve yourself in. And previously, we were providing that. I think that's a distinction between the dues checkoff versus the political activity. So that's the position we're taking, and I'm sure we'll have lots of discussion about that. I don't think we had any changes on union information, use of the email system, use of the paging texting. In terms of union coverage, our position is the city retains the discretion to approve IAF coverage in accordance with department operations and procedures, SOP. One of the things we do want to talk to you about is getting a better understanding of when the IAFF provides payments for, what do you refer to it as? Union trade. And I think we need to have a better understanding of how that works, what responsibilities we do or don't have regarding that, because it involves an employee with the city. How is that income being reported? Are you responsible for that? For IRS notifications, for preparing forms to make sure that the appropriate deductions are being made and so forth, so. And if there's some federal law exclusion or state law exclusion, however, you can provide that information, that would be helpful. Article 6 is currently titled Prevailing Rights. We refer to that as the entire Memorandum of Understanding. And it's quite a lengthy position that, or comment that we've written in that regard. Again, I think that the title says it all. This is, when we enter into this agreement, this is the entire memo of understanding. However, we do have the letters of understanding arrangement that's built into the agreement as well. We expect to have a very robust conversation about this section once you've had a chance to read it and thoroughly understand it. Next is rules and regulations. There is a title change there because the department doesn't call them rules and regulations anymore. They're policies and procedures. Is that the case, Chief?
Yes, sir.
All right. So the IAFF agrees to comply with all department policies and procedures. We've reduced this a bit, simple statement. Unless otherwise altered by terms of this agreement, policies and procedures as outlined in the city employee handbook are applicable. Okay, compensation. The city has an interest in adopting a market competitive and internally equitable pay plan. The city is also interested in reviewing the differentials in the pay plan between basic EMT and AEMT and paramedic. I noticed that one of the things that the pay plan that we received talks about is some compression issues, and we need to figure out how to relieve some of the compression that's occurring, because I think that we may have issues with employees not wishing to ascend to a higher rank because financially it isn't worthwhile to do so. And that's what compression typically does. No changes to 8.1.2.3.
Tom, that's part of what we propose to discuss along with this, with 8.1.1.
Okay, all right, okay,
8.1 the rest of 8.1 and the rest of 8.2.
you know, this is all part of the pay plan, I'm sorry,
Right.
yeah, exactly.
The next one is 8.3 longevity.
Okay. Longevity, obviously, you're completely familiar with what we have done in terms of the LPOA and the city employees in general. We're proposing similar with you. That would not apply, obviously, until 1/1 of '20. You have a current agreement that provides the current provisions that you receive. MOU, and by the city commission, let's see. Longevity goes through 8.3.2. Periods of military service, here's where it starts, where we make reference to the employee handbook. Again, we would leave section 8 in there and title it, and then just say, provisions for this section are provided in the employee handbook. And then they would be specifically added as an appendix to our agreement with the IAFF. So that takes care of 8.3.4.5.
Down to 8.4, which is the skill incentive discussion.
What's that?
8.4 starts the skill incentive discussion, and we asked, and that is also part of what we'd like to talk about with compensation.
Yeah.
So that takes us completely through that 8.4 section. And,
So is the next section acting officer?
Yes, yes. We wanted to include all of those with the compensation discussion when we had it.
Right.
But the acting officer, the first section, 8.6.1, we have some proposed language, but then on point 2, we would like to take that back with the compensation discussion.
Right. But 8.6.1 then would be the next one we're proposing a change, right?
Correct.
And there we're saying, in reference back to the resolution, assignment of personnel is one of those management rights that is identified in the resolution, and based on the resolution is not even subject to discussion, let alone negotiation. Callback and overtime calculation. Again, the handbook reference. 8.72, employees in the fire medical department. Propose that this section be replaced by language in the employee handbook, which will, after the calculation of time and a half going forward. Remind me about that, Lori.
That should say, will alter or affect the calculation of time and a half going forward. And actually, Shaun might be able to speak to this better than I. The employee handbook calls for overtime at the end of a pay period, not at the end of a shift. And currently, this language says that overtime will be paid at the end of any given shift, whether or not you've had the full pay period overtime.
So I know it as the black line. So say you work a Monday, Wednesday, Friday, you take sick leave on Wednesday, then you come back in on Sunday and work, that wouldn't be considered overtime, it'd be considered straight time under the federal law. That's what we're talking about there.
Anything else there?
No.
What's the next section then, Lori?
8.8 is military leave.
And
And-
that's the same as it is in the employee handbook?
Mhm,
All right.
yes.
So now the whole next page is employee handbook items.
And the language in this, in the MOU is identical to the handbook.
Yeah.
Except where we have noted, and there is one section that is different.
What was that?
It had to do with a reference to
Yeah, there was a
Terry.
question that we had.
I put it in here somewhere.
It's the language about family. It says something kind of unique
You know,
that's not discernible.
it's not in this section. I think we have yet to get to it yet.
Okay, all right.
This language is all identical to the handbook. Right.
Then 8.9, paramedic certification attainment educational reimbursement. That's all it says.
This was
Do we miss?
clean up, because the last time we were negotiating, we were moving from the, a different EMT designation, EMTI, wasn't it? To AEMT, yeah, and
Yeah.
so this language was put in there to help with that transition or clarify who would pay for that transition, but it's done now. So this is clean up, in our opinion.
Then the next page is clear, there's no changes. All the way through life insurance, then health insurance. And we're saying that, the city shall obtain employee input concerning the selection of health coverage, life insurance carriers, and benefit packages. An employee selected by the IAFF president shall serve on the city healthcare committee. You'll note what we've removed is, and shall select the benefit package and products providing the best coverage for its employees. Best is pretty subjective. It's hard to know what that's supposed to mean. And I'm not sure that that criteria could go to, is it best for the cost? Is it the overall regardless of cost? That language is kind of nebulous in my book. And I think it needs to be, if we're gonna have some sort of language as to selection criteria, it needs to be more objective. I think that's too subjective. All right, terms and conditions. Yeah, that's a repeat of the employee handbook comment.
And this is a discussion about that this is the place to have those discussions versus other times and venues.
And as that conversation continues, 9.2, annual work hours. Of course, the number of hours are part of the assignment, and we believe that is a management right pursuant to the resolution. Vacation, provisions for this section are provided in the employee handbook, as is 9.3.2, 9.3.3, and 9.3.4. I think the only change in 9.3.5 is the change of words from department rules and regulations to department policy and procedures. Sick leave, again, it's employee handbook. 9.4.2 is the same as is 9.4.3. We had a question on family sick leave. We just left a question mark there. Family sick leave may be used annually for illness within the immediate family, which shall.
Tom, this is the military discussion.
Yeah, here's the military comment, and if one of you knows the explanation. Military, those members covered are different than immediate family and shall be honored as outlined by law. Is there a statutory reference there that we need to reference here? Because I don't know what that means. So maybe, you don't have to answer that now, but maybe you guys can look at that and tell us. 9.4.5, nothing there. 9.5. Employee handbook. City proposes, this is one where this is the only one that has this provision, as I understand it, Lori, is the IAFF.
Correct.
And the sick leave payout, is the, fire department is the only one that gets credit for the first 5 years. All other employees are exempt on the first 5 years.
They would forfeit a separation.
Right. Wellness days administered by the city employee handbook. We note, for purposes of clarity though, that would result in fewer wellness days. Your wellness days are significantly higher than all other employees. Sick leave, employee handbook. That's for 9.7.2, 9.7.3. And under 9.7.4, we note that it's department policy which needs to be updated to match the provision in the agreement. The policy's currently inconsistent with what is in the agreement.
Yes.
Holiday time, provisions for this section are in the employee handbook. 9.8.4, city proposes to eliminate this section as any pay or benefits the IAFF receives should be subject to negotiation in the agreement. Okay, 9.9.2, again, out-of-city training, those are already in the employee city travel policy, not the employee handbook, and that would be another place where we would add that as an attachment, as an appendix to the agreement. Uniforms and safety equipment. I think the one thing the significant thing here is uniforms shall be provided subject to IRS regulations. You asked for, in this provision, you asked for $500, and that was for both shoe and clothing allowance, correct?
Correct.
Yeah, and what we've said is $125 for annual shoe. I suspect that will be further negotiated. And we provide the uniforms right now on a quartermaster system, right?
Can we call it the quartermaster system, chief?
Well, it is, that's what, basically it's the general quartermaster system, managed by Captain Gooch and Chief Fagan.
So we provide at no charge, right?
Yes, sir.
And we have one of the officers designated to provide it and kind of control the inventory and disperse it out as required, right? Okay. I think in reference to the LPOA, I think the LPOA agreement talks about, so we get rid of that system, is that what you're suggesting, and just,
No, sir, this is supplemental clothing items, so base layers, gloves, boots, the things that the department doesn't provide.
okay, so it's more of equipment type, personal equipment that you use, rather than a uniform? Because the uniform,
If we call it uniform, if we call it uniform, that was a.
well, it says
Choice of words.
clothing allowance.
Yeah,
And
I mean, to a degree, yes, our uniforms are provided by the department and the city, but there are other items that I think most firefighters use,
like what?
that we can get into further when we talk about it, but,
Fine,
yeah.
okay, I get it. All right. Next items, no changes on that page. And then under personnel reduction, that actually is addressed in the employee handbook. Now, I would say that is not as complex as this, it's much more simplified. I would say that that is viewed as a management right covered by the resolution. Employee conduct, section in the employee handbook again. grievance procedure, city wishes to discuss the entire grievance procedure. I think the significant thing I would note in your grievance procedure is the ability to file what I would call a class action kind of grievance, so that you don't need a particular employee to grieve an event. You have the ability to grieve a provision in the contract that you find unacceptable. I have concerns about that because we have just finished a negotiation, we have an agreement, and then you bring it back to the city through this class action type of an event. My bigger problem with it is, it doesn't get resolved by, mutual agreement between the city and ultimately, and the IAFF. Ultimately, it goes to mediation, which I think is mislabeled, because the mediator's comments or findings are binding on both parties. That makes it binding arbitration, that isn't mediation. And so, you now have a third party interpreting that agreement. So that is distinct, in my opinion, and it's entirely different than the grievance procedure that applies to all other employees. So I at least want to understand why that was there. I'd like to talk about alternatives to those kinds of conflict resolution, and feel that the grievance procedure should be somewhat uniform. I think it is, with that exception. I think an employee grievance procedure is pretty much the same as it is, with the exception of the class action approach or the binding mediation to combine the two terms. Next is the next page is all blank, so is the next page, 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 so is the next page. These are all the grievances. All right, and then we get to minimum staffing, and again, I would say that is a provision, management right. I'm willing to talk to you about that issue, but I suspect that at times the city, over its history and over its future, will have very serious, potentially serious financial issues at some point. And quite frankly, I think not only the fire department management, but the city management may have to deal with some staffing type issues in that regard, and to bind ourselves to those numbers that you're referring to, I think precludes us from managing the operation based on our resources, and I think that's gonna be critical to us, so. Next page is all blank, and then we get to 9.21, station maintenance. We believe that's, how that's handled. It's pretty clear that that's listed in the management rights, as it is for maintenance assignments, apparatus maintenance, safety standards, and it seems to me that is the fire chief and the command staff's responsibility to make those determinations. But that certainly doesn't preclude any of the employees from reporting safety concerns and expressing their views. But I'm big on authority / responsibility. And if you have the authority, you also have the responsibility. But that doesn't mean people shouldn't inform the person with the authority that they have concerns about the safety of something, and putting that person on record. And that, quite frankly, probably adds to that person's responsibility, having that notification. Usually once you've been noticed, okay, by an employee or by a member of the public that there's a safety concern and you don't deal with it, you've probably created a lot more liability to your responsibility than you had to begin with. So I don't mind language in there that says that employees, when becoming aware of a safety issue, should report it up the chain immediately, something to that effect, because ultimately it is the chief's responsibility to manage the department and make sure that it is a safely operating department. Okay, next section is 9.24, voluntary demotion. That's gonna be, I suspect on both sides, a pretty significant discussion. We propose eliminating this section as it's covered in department policy. That isn't the section I was thinking about, but going back to department policy. Next is section 10.1.2. And I think instead of saying the union makes the appointment, the IAFF should recommend 6 members of the team, and the chief makes the actual appointments to the team. All recommendations shall be forwarded to the chief and the union president, and and our language says all recommendations shall be directed to the chief with copies provided to the IAFF president. Next sections, no changes until we get to 10.2. And there we've added all on-duty injuries shall be covered by workers' compensation as outlined in the Kansas Workers' Compensation Act and provisions outlined in this section. Next is reporting of injury. Reporting of injury, the injured employee shall complete the appropriate documentation pursuant to the employee handbook. The chief may assign the health and safety program team or any other person the chief deems appropriate to investigate, review, and make recommendations for corrective actions. Next section, 10.2.3.1, we had a question mark on that. And that, I guess we want to just have a discussion about how we derive those numbers and how we work back and forth in terms of workers' comp and the pay and back and forth. As I understand it, we're making up the difference between what workers' comp pay is and full pay. Is that what this provision talks about?
I believe so. That's how I interpret it, and
Okay.
that's how it's currently done.
Okay, all right. Well, we have a proposed alternate language. We just want to make sure we understand what the intent of that section is. I think maybe if we stay with that intent, the language could be clarified to make it clear. Modified duty. I think what we've done here is made this more the chief makes the call on all of this very specifically. And instead of light duty, it's referred to, I think, in the department chief as modified, so we've changed the title of it.
That's on duty.
Pardon?
You said that from 10.3.1 was a modified duty if it was a work-related injury.
Yeah, it's the same with 10.3.2. No changes until we get to 10.5.2, and this is a pretty simple thing. We're just removing gender reference from that part of the language. And if you find that elsewhere in the document that we've missed, please point it out to us, because we're trying to make all of our agreements gender neutral. Fit for duty, 10.5.4, the responsibility for determined day-to-day fitness for duty shall rest with the city physician. All fitness for duty criteria shall be based on NFPA 1582, shall be in accordance with any applicable Americans with Disability Act procedures. then we go to 10.56, record keeping will be conducted in compliance with all relevant statutes. We're missing a T there, and regulations. Section 10.5.7 proposes to eliminate this section under management right. This is establishing the criteria, the physical criteria that gets evaluated in the medical evaluation. I believe that is a management decision. And that's what that says. Station fitness. Basically, the chief makes the determination on the purchase of equipment. 11.1.2, the shall recommend 6 members to the training program team. The chief shall approve all team members. Next is 11.1.4, all recommendations shall be provided to the chief with a copy provided to the IAFF president. We had some questions on the concept of the living document, not necessarily any disagreement, but we think it could be clearer as to what we're trying to accomplish there. So we've left question marks there. Under section 14.1, the city proposes to eliminate these sections because neither federal or state law grants this right. National Labor Relations Act excludes it from its purview of local governments. The city has not elected to be subject to para and instead is governed by Resolution 6817, for which the applicable language is contained. And the rest of the agreement, we don't have any other comments on. So I think as much of it is cleaning up and simplifying the document. I will tell you that I think by count, the chief went through and the chief thought we had about 20 significant areas of concern that we want to communicate to the IAF and have discussions going forward on those. So that's it.
Okay. Well, this being the first time that we've seen the interest in proposals, we really need probably more time to discuss.
Clearly.
To understand them, and than we would be able to do with just a caucus today.
That's fine.
Can I speak to that, Tom?
Sure.
Since our last meeting, we reserved 2 additional conference rooms. So for caucus, we have this room that's right behind here, and then, I don't know if you're familiar with the ground floor of City Hall, but if you go down the stairwell and out the door, there is a conference room right through the break area that's pretty private, if you'd like to use that. It has a telephone in there, it has city intranet and internet access if you would like that. And I thought that would give you a little more privacy if you'd like to have that. And those are reserved for the duration of all of our meetings, plus a half an hour before and after. So if you want to arrive early and coordinate before our meetings start, it will be reserved 30 minutes prior to our established meeting times.
So our next
And then-
meeting is scheduled for next week?
Yes, and I'd also like to discuss that as well, as our schedule. And you'll notice on the agenda that I put all of the future meeting dates that we discussed at the last meeting. And we've been able to reserve all of the rooms, all of the 3 rooms that I discussed. May 13th is a problem, so we have to be out of here. There's another meeting that cannot be moved, as it's tape recorded as well, that begins at 11 on May 13th. So I told Bobby that we would adjourn by 10:30, so we can either start at 9:30 and go to 10:30, or kick up that meeting time from like 8:30 to 10:30 if we would like, on May 13th. Excuse me?
I'm just asking them.
Oh, sorry.
The suggestion is to move it up to 8:30.
That was the 13th?
May 13th. We have to adjourn by 10:30.
We're comfortable with either one, or bumping it up to 8:30, or just cutting in the last hour off, I think it's important to try to meet as many times as possible.
So,
Whatever we gotta do.
I
so
would agree.
Dean, so you're saying 8:30, and how long is that supposed to go?
It would be, if we bumped up the meeting time by 1 hour, instead of meeting 9:30 to 11:30 as we previously established, we would meet 8:30 to 10:30.
Okay.
And so it would keep our 2-hour time frame, but it would move it forward earlier in the day by 1 hour.
And you're okay with that?
Yes, sir.
Good.
So we'll establish the May 13th time as 8:30 to 10:30, and all other meetings are 9:30 to 11:30 that are listed on here on future agenda, or future meetings. And I suppose if we're going to caucus for the remainder of this session, we probably should set our agenda for the next meeting, and then break for the remainder of the day.
Fair enough. If I could make a suggestion in terms of the next agenda, maybe we just start going back through everything and just, I mean, we could take on pay first, or we could take on anything, but I think we need to get through the agreement, and I think some of it is easier than other parts of it, but, I mean, you probably wanna strategize that as well, but, there's ways to do it on a subject basis or on just the way the document lays out, section after section, so. You wanna think about
We
that?
really just wanna be prepared to speak to one of our proposals. So, you know, in advance, we can do that.
Okay.
So just begin moving through the agreement from the beginning.
I don't know that that's what I heard from you.
Oh, I'm sorry, I was making notes.
You guys wanna
You want a caucus
for 10 minutes?
to talk about that? Yeah,
Let's do that.
that makes sense.
Caucus for 10
So we'll just be on there.
Yes, sir. We're okay, Kurt.
Very good.
Agenda for next meeting.
Before we give our suggestion on that, Tom, we do just want to make a comment. We appreciate it being set up in a format like this. It makes it very easy to see where we're at. But in that regards, you guys are proposing some pretty significant changes to large portions of the contract. We just wanted to publicly say that we believe the contract that we have has done a lot to create the career department, the professional department that we have right now. And a lot of our perspectives are very different, and we look forward to having some lively debates. So,
Fair enough.
So we'd like to really start just with all the language that is being proposed to be replaced by referencing the city handbook, making it an appendix. We think there's enough in here to merit a meeting.
For that alone.
I'm sorry?
For that alone.
Yes, sir.
Okay.
And then each side could be prepared to speak to it.
Sure.
So.
Would you like me to prepare an agenda and send it out to everybody for next time?
For confirmation. That makes sense.
I can also send out the document for an electronic reference. That'd be all right?
That's fine.
So I'll send both of those out. I'll go upstairs and do that.
Anything else for the good of the order from anybody around the table?
Did you want the memo?
Yeah, hand out the memo. The memo I went through before, we didn't hand that out. We'll make sure, we're gonna hand that out to you. So, hearing no other business,
Good.
we agree to adjourn?
Yes, sir.
All right, thanks.